Hi, I'm Bill Jolly. Welcome to Live Free TV. This is the second episode. Today we're here with Dan Itse, State Representative from what district, Dan?
Rockingham District 10, Fremont.
Okay. And Paul
Ingbretson.
Thank you.
That was wise.
And the Honorable Paul Ingbretson. And where were you a state rep?
I was a state rep for 10 years coming out of North Haverhill. And I represented Warren, Piermont, and Benton.
Okay. So today we're going to be talking about the family division of the circuit court.
The family courts were started as a pilot program. Representative Weiler put in the original legislation, I believe in 1995, and they started in Rockingham County and I believe Grafton County.
Okay.
And I came into the legislature in the 2001-2002 session, elected in 2000.
A couple weeks ago.
Yeah, a couple weeks ago. And I think it was during the following session that we expanded the pilot program to Hillsborough and one other rural county, and I can't remember which one it was, Sullivan or a county like that. It operated well for another couple years, and in 2005 we brought the system statewide. Mm-hmm. Not that I think it is now fully implemented in every county, especially with the being reorganized into the circuit courts, and it's now the family division of the circuit courts in 2011. Now, that's the general history. The chief most problem, well, the purpose of it, the family division was to create previously everything had been handled in the district courts. Mm-hmm. And so you were commingling low-level criminals and families. And the legislature said, gee, that's not really a good idea. You don't want, parents and possibly children sitting in the same waiting room as shoplifters and whatever. Yeah. So we created the family courts. It's something that was going on nationally at the time. To create a cadre of judges who were expert in the issues regarding divorce, and also to physically separate those enduring a divorce from low-level criminals. It sounds very rational, and I don't disagree with the intent.
One of them is that Grafton was one of the first three that was used as a pilot, as part of the pilot program. Grafton rejected it. Grafton didn't like it.
Really?
And it's unknown to me why that didn't have more weight, considering it's 1 out of 3, or why they should have said, let's try a little longer.
1 out of 2.
1 out of 2. And why we should have gone forward.
What was there? What was their reason?
I don't actually recall. I don't know if I knew, even if I ever heard what it was. But it was absolutely
for some reason,
not acceptable.
1/3 of the people testing the system.
One half.
Thank you.
Yeah.
Of the city. I'm not very good at math. That's why.
Well, one half of the jurisdictions, not one half of the people, because Rockingham's a much bigger county, much more populous county.
So 2 entities.
Right.
1 out of 2 says this really isn't working.
Right.
We got to talk about it some more.
Mm-hmm.
Right.
Okay. So I'm sorry. Go from there.
Well, no. That's number one. And the second point, is one of the more fascinating ones to me. Where this originated is fascinating. I don't think this originated in New Hampshire as a problem in New Hampshire.
Okay.
I think this originates at the federal level with an agenda. And my sense of it is everything about this is agenda-driven. It looks like it's agenda-driven. So they come in and say, don't you have a problem? Don't you all of a sudden see there's a problem here with mixing these things?
Okay.
I really don't recall there was a big noise about getting family separated from criminal. And even though divorces were becoming more and more common.
Yeah, absolutely. Yeah.
But the results, and Dan will eventually, we'll all get into, the results have been similar across all states. It's been quite a bit of a disaster for a lot of people.
Okay.
And equity courts, which this became, is coming straight out of the federal government with federal dollars. So
I don't.
Well, that's what Weiler told us. He said this wouldn't have happened.
Who was
federal funding.
Ken Weiler from Kingston.
He was the chief sponsor, or one of the two sponsors.
Superior Court. Every time you have a tort case,
damages.
Right. That's settled in an equity court.
You will pay this other person
under
for
equity
damages.
jurisdiction. So equity jurisdiction is not itself fundamentally flawed.
Okay.
The flaw has come in the way that the family court was constructed, in that it is, in essence, totally outside of legislative control, and the way the courts have set themselves up is completely outside of judicial control.
So let's compare that to a criminal matter. What would the difference be? We have criminal court, which was a district court issue, correct? And then we have the family court, or the family division, which was pulled away from the district court, and that had an impact in that now we had judges. What was the language that you brought up earlier?
Well, remember, in that equity jurisdiction is the power to A, compel performance, and B, to act where there's no specific law.
Okay.
Nothing that says that you have to give Jane 60% of the property and Joe 40%.
Okay.
Okay. There's
no
there's nothing specific. We then, for instance, in probate court, there's a chapter of 20, 30 laws that tell how the probate court exercises its equity jurisdiction.
Mm-hmm.
In the analogous section of the family court laws, what it says in essence is, in spite of laws to the contrary, they have equity jurisdiction in everything they do. So even if we say in another statute they can't do it some particular way, they say we can if we want to.
So when there were 6 words that we talked about.
The 6 words are law to the contrary notwithstanding.
Law to the contrary notwithstanding.
Which means in spite of law to the contrary.
So no matter what the law says, this particular court, the judge within that court, based on whatever he sees as being equitable in his mind for whatever reason, without any justification?
Well,
I mean, where does it go?
We don't know. And here's a perfect example. We have a law that says you have to determine child support according to the child support guidelines.
Correct.
Or if the judge sees another method as appropriate, they have to write it down so that you have something to rebut if you don't think it's equitable.
Sure.
But they still don't. They don't write it down.
I've heard of that happening.
Right. So even though the legislature saw a problem that people were not being able to rebut bad decisions, and we put a provision in the law, there are cases where the judges are still ignoring that statute because law to the contrary notwithstanding.
And so that's if something goes to an appeal, oftentimes that's the argument?
They never say it, they just ignore it.
Before you go there, though,
Yeah.
it doesn't just say laws contrary. It says, or court rules to the contrary.
Well, the court rules are themselves. Rule 1.2 says that in the interest of justice, the judge may waive any rule not in statute.
But then the statute says laws of the contrary notwithstanding.
Right. So
it's a cyclical dilemma.
So you go into court.
To sound professorial for me.
Right. Well, you go into court and you have no court rule or no statute upon which you can stand.
Okay.
True.
We're talking about kids and taking care of kids in one fashion or another. My experience has been that isn't always, personal experiences, that isn't always handled properly. What about the part, and I'm paraphrasing, of the law, which is the opening of 461A, that says that the court shall take into account first the welfare of the child?
And what's the judge's perception of the welfare?
Welfare of the child, sure. And even contrary to that, notwithstanding that, a judge
but it's left. We have a list in that statute. We have a list of criteria that are factors that should be considered in the best interest of the child.
Sure.
Okay, but it's not limited to that list. It doesn't. It's not a conclusive list. It's a non-conclusive list. If the judge feels there's some overweighing factor, somebody made him angry when they walked in the courtroom.
Right. Dan's forever involved with the family division.
Right.
With the family committee.
children family law.
Understood. Yep.
So he's got the long background and the deep stuff.
Okay.
I'm involved from probably 4 years even before that with having seen these cases.
Your observation back then was what? Just so we can get a
Well, what I'm trying to get at is that what we saw was there seemed to be an accumulation of these things among just a few of the many judges out there. But so what we're finding is that out of I want to say that 30 some courts, 27 courts, I forget what the number is, that deal with this family divisions.
Mm-hmm.
There are maybe 3 to 6 that are persistent problems.
Okay.
And one of the people that was injured went to the Supreme Court and looked up how many of these attempts to get the Supreme Court to take the appeal, where they came from, who they were with, and all that sort of stuff. And he found very much that they were in basically 3 areas, all down in the southern part of the state.
All in Rockingham County.
Yeah, and so it appears that there is either agenda-driven thing going on among some of these individuals that include the judge, because the judge is signing off or not doing their job, or these people just don't have any sense of justice, any sense of what equality is in the courtroom. Mm-hmm. And so what we're seeing as a matter of routine in some of these places was one person would get to bring experts in, the other one would be denied. One person would be required to bring all their money matters in, the other one would be told to and wouldn't be expected to follow up. Oh, so the inconsistencies were phenomenal in the sense of just the sense of equality, the sense of equity,
right,
the sense of justice. So if that is going on,
so it created a perception of bias.
Oh yeah.
Yeah, sure.
Well, I mean, to the extent that certain individuals would kill themselves over it, yeah.
Right.
Okay. Another big issue is when somebody is required to pay a huge amount, particularly back child support or back alimony. Mm-hmm. Right. There's no investigation done to ensure that they in fact have the resources to do that.
Right. Okay.
A finding of fact.
Right.
Now the thing that's so cool about this, I mean, in the sense of what we're really getting to the crux of this, these people are required by our laws. He brought it forward in Representative Itse's committee,
right,
and passed by us to correct some of these things, which are then being ignored in these divisions, which have this quote equity power, the power to ignore our laws.
Right.
Now, so you see, we aren't in a position to fix it unless we're in position to control a court.
Because the people, in effect, have lost their power when it comes to controlling their judges.
And that is very precisely put. Yeah. They are
I'm paid to speak.
The courts are
not here.
are outside of popular oversight.
Mm-hmm.
You know, if you're talking about judges themselves, I mean, one solution is to figure out some way of either making these guys pass tests that show that they have the skill to actually do justice, and don't have agendas. And if you could eliminate those two problems, you probably would eliminate even more. Now, remember, this isn't a huge part of the family division. It's a fraction that's causing this problem.
Right.
I mean,
but it's not a fraction. But it's a lot of people, human beings,
that are impacted.
Well, there's children that are impacted.
Absolutely.
When the war goes on and cases they go on for years.
Absolutely.
Because this judge is incapable of getting to a place where they can get both sides.
You go into court and you actually have an adjudication, you have hearings.
Yeah.
And then an even smaller fraction of those become these cases that just go on ad infinitum and really go seriously sideways. If you went back 10 years ago, it would have looked predominantly like an anti-man thing.
Okay.
Still does in the majority of cases, but
it's not exclusively. Right. And even some of the worst actors that we've seen as marital masters, it's not.
So you see some improvement there?
No.
Oh,
I'm just saying there is no particular rhyme or reason as to why a case goes sideways or whom it's going to go sideways against.
We do see that the judges appear not to be reviewing things that are going on. We see that judges appear not to be looking close enough. We looked, where is this coming from? Why is this happening?
Yeah.
Because we saw arbitrary law. Now, by definition, arbitrary law is no law at all. You know, and in fact, the very definition of tyranny is arbitrary law.
It's arbitrary power and oppression.
It's right, but it's arbitrary activity by anybody in government. We couldn't make any sense of the stuff we were seeing. Now, we couldn't get judges to come before us or marital masters to come before us and explain why it does make sense. Yeah. What I'm really trying to get, the whole nub of this thing for me is this one little idea: do Americans actually believe that they should submit without assurance of justice? Should they submit?
Well, a reasonable expectation of justice. I think
right.
we're all entitled.
Yeah.
Right.
And I'm saying that you don't have a reasonable expectation of justice if there's no binding. If there's no, the whole point is to bind judges, to bind governors, to bind legislators, to bind
public officials.
But to bind public officials, executive branch. If you don't bind them, we do have a really serious problem. And so, where in the heck do we come up with equity courts? Equity courts where you can say, no, you guys can just ignore all law. No, you can ignore the court's rules and automatically and all that stuff and just do what you feel good about.
Right.
I mean, what kind of a thing? We've long since realized that's crazy. And at one point,
I think we tried that once.
Early on, and we said no equity courts.
Yeah, right.
So here we are. Thank you to the federal government, which is, to me, the source of most tyranny in this nation today. Is the source. This really is the source.
Okay.
Whether you like it or not, it just keeps eking its way down.
Tyrants like tyranny, no one else does. Right.
So that's all. And I have to say this, with all the other stuff, that is the crucial thing. Can we figure out how to not have those kinds of courts?
Yeah.
And still, maybe not have kids in the family in the criminal courts.
Right.
We can do both. We can do this.
It's really quite easy. I mean, not necessarily easy to effect, but structurally, you take away the unrestrained equity powers, and you enforce. You put in laws that are then enforceable upon the judges to follow the law.
Absolutely.
That's
the people rule or they don't rule, right? So
shouldn't there be a process by which someone that feels like they've been treated unfairly by the lowest court can go and say, hey, this judge has a bias for whatever reason. I'd like you to look at the facts, hear additional testimony if you wish, and come up with a conclusion of your own, and then give instruction to that lower court judge.
I was always surprised, you could answer that, Dan, but I was always surprised that didn't exist, that we didn't have a middle court.
Right.
Whatever you want to call it, however.
Well, it would be the superior court.
It would make sense for it to be the superior court. So that's one thing, and the other thing is we have two parts of the Constitution that require the redress of people's grievances.
We are actually
you're
doing that. Well, we are one of those middle positions.
And we also need to hitch up our pants and act like a general court.
Yeah, for sure.
Okay.
Redress of grievances has not functioned in any meaningful way for 100 years.
Yeah, it was over 100 years, right.
So last term, we went back to at least hearing them and trying to figure out how to manage them.
Mm-hmm.
What can actually be the product of it?
Mm-hmm.
There's
how that would all take place.
And how that would all take place. And then there was an election.
And things change. Right.
So if the people want to have the legislature, not as a court of appeal, because it's not really, and it's not an appeal in the traditional sense. It's where you go when you believe you have been denied by the court system due process, or by the law enforcement system,
the executive or the judicial,
right, or official capacity,
right?
Yeah. Sure.
Is there some way that you have actually been aggrieved?
Yeah. And it have to be determined whether or not that happened, and then redress of some sort.
Well, and then what can we actually do about it? I mean,
we got through the hearing stage. We didn't get redress.
Right.
People didn't get redress.
Understood. Which is the purpose.
In response, we said, yeah, we agree with you.
Right.
But we never followed through for lack of capacity. That's maybe some of my personal capacity to grasp what we precisely had to do. We know what that is now. We know exactly how.
Well, and also by the time you had gotten through the hearing process and come to conclusion, we were already in the second year, so there wasn't really an opportunity to provide redress. I put in 2 bills of redress this last term, and both bills for redress, one of which I think was particularly justified, were both rejected. One was particularly justified, the other was insignificant in value, but both were rejected.
Okay.
2 years ago, almost to the day, I mean literally, we had listened to all these things. I sat in, though I wasn't on the committee, I sat in on a lot of them.
Right.
And people started talking about equity courts, and Paul called me up one July night and said, people are talking about equity courts. And we just started looking stuff up in Balak's law and stuff, and we said, hold it. And then we're on the phone, and literally I went and looked at the equity jurisdiction, and I said, oh my God.
It's verbatim?
Oh yeah.
Yeah.
Oh yeah.
I mean, this is...
Well,
So this is like common law.
so what was interesting, Bill, though, it truly was most interesting to us was we said this can't be happening. Doesn't make any sense. Now, we started seeing a little bit of a pattern. We started seeing self-employed guys.
That is one pattern.
We're being doubted in the courts. And we have guys that we know wouldn't do that and have never done that. And we have testimony that they haven't done that. You know what I mean? We
So were they accused of being willfully underemployed? How is it presented?
things
No,
related.
they're hiding money.
They're just sure there's money there somewhere, but you can't point where. There's no testimony, et cetera, et cetera. And so there's an assumption, and a lot of this assumptions can happen because you don't understand how business operates. You know, and I tell you what, a lot of judges don't know how business operates.
That's why they're judging.
But we saw a pattern there. So, what does that indicate to us?
Okay.
Though? That there's a thing that's going on. There's so much more. Sorry to admit this, but it's so challenging. Is that a judge can just say, you know, I just smell something.
I got a feeling.
Where's the evidence?
Right.
Now, this isn't okay. You know, this isn't okay. You can have your entire livelihood ruined without evidence.
I had
some
a
judge who may be prejudiced about self-employed people or something.
I put in a bill this last, I think it was the first year of this term, maybe it was the second, doesn't matter, to require a finding of fact before somebody can be held in criminal contempt for not, civil contempt, because that's
for not
unrestrained.
reporting?
For not paying some large amount of money.
Like an arrearage on child support.
Arrearage on child support, to make sure that you can't put somebody in jail for $20,000 when they don't have $20,000 to get themselves out of jail.
And there's no evidence in any number of cases at all. In fact, in several cases that we heard about, the money had to be borrowed. It had simply to be borrowed for this guy not to go to jail. Now, borrowing is not one of those standards. That's written in law, which they can ignore.
Federal Supreme Court case says you can't require somebody to borrow to get out of civil contempt. We've seen people lose everything based upon a sealed envelope.
Yes,
And
yes.
they were not allowed to see the contents of the sealed envelope.
What was the subject?
The subject was one of child support and custody.
And so one parent had some information that was
Allegedly
had information that a judge allegedly viewed and made a ruling on without any cross-examination.
Well, this is worse than that because the GAO actually, I asked specifically the GAO, I said, what kind of thing would make that happen? Was that even possible? I said, would it have to? She said, oh, I can't tell. He said, I can't tell. I can't tell. I said, well, what kind of thing? It'd have to be pretty serious, wouldn't it? Like, and I named child abuse, and he said, yeah. Well, eventually he said, all this guy has to do is X, some Mickey Mouse little thing, and he can see his child anytime he wants.
Knuckle under the court.
And it was just about bowing.
To the court, bowing to the
It
court.
was about bowing. It had nothing to do with anything
Did you know-
serious, and he still wouldn't tell me what it was.
So
but he said, all he's got to do.
Where do you get to be denied your liberty
Right.
without the opportunity to see the evidence against you?
Absolutely. Absolutely. So when you can take away the right to law, right? In other words, you have the capacity to say all law notwithstanding. That means the Constitution. Do you realize that means
United States Constitution
that's
doesn't
the number
matter.
one law. That's the supreme law of the land. Any law to the contrary notwithstanding.
So, do you see this as a potentially federal issue where the federal court should be brought in to bear on it?
I don't know.
I wouldn't go there.
My point.
No?
My point.
I would go to the general court. This is a matter for the general court to take in hand.
Okay.
That's the legislature.
And this is for other people to decide. Can there ever be a court that says, we will ignore your laws? And we don't care what these guys are saying. We really need to consider that can't be right. That can't be okay.
Sure.
For a person to lose the right to see his child with a sealed envelope that has something in it that we know for sure is insignificant.
Wow.
But we don't. But he can never find out what it is.
But even if it isn't insignificant, he didn't have the chance to look at it and say, that's not true.